Good morning. Can folks hear me?
Testing.
Good morning. Mr. Rubin, can you hear me?
Yes, I can, Chairman.
Perfect. Thank you. Good morning, everyone. I think we'll go ahead and get started at the May 9th meeting of the Oil Conservation Commission. For the record, Dylan Fuge, acting OCD director, acting sheriff, Oil Conservation Commission. I am on official work travel, which is why I am not at the meeting in person and am participating remotely. But I see from the room, I have conferred with council on that matter, and I also see from the room that we have the other two commissioners present in person. And so I think we can begin. Can the clerk confirm that the meeting is being recorded?
Yes, we are recording.
Perfect. And we will move to the first item on the agenda, which is approval of the agenda for the May 9th, 2024 meeting of the Oil Conservation Commission. Asking my fellow commissioners, are there any comments or changes to the agenda?
Mr. Chair, there was some discussion in the room today about moving the JITC case number 23655 to the top of the agenda so we could let about half of the lawyers here go home, or rather back to work. We could discuss that, or I could just ask for a second.
I would second moving that up. We'll call it a motion to be nice to lawyers, I guess.
Who wouldn't want to do that? So.
Right.
And so we'll need a roll call vote as one of the members of the public body is appearing virtually.
Yep. Commissioner Bloom?
Approve.
Dr. Mpoma?
Approved.
Let the record reflect that Commissioner Bloom and Dr. Mpoma were present in person, voted affirmatively, and I voted affirmatively remotely. And we'll revise the, can I get a motion to approve the agenda as revised?
I so move.
I second.
Roll call vote. Commissioner Bloom?
Approve.
Dr. Mpoma?
Approved.
The record reflect. The motion was approved unanimously with Chair Fuge voting remotely. The next item on the agenda is approval of the April 11th, 2024, the minutes from the April 11th, 2024 meeting. I know they were circulated in advance by the commission clerks. Do my fellow commissioners have any amendments or edits to those minutes?
No, Mr. Chair, I would move to approve the minutes.
Mr. Chair, I will second.
Roll call vote. Commissioner Bloom?
Approve.
Dr. Mpoma?
Approved.
Again, let the record reflect the minutes were approved unanimously with Chair Fuge voting remotely. Moving on to pending cases and consistent with our amendment to the motion, we will hear first case 23655, application of the Joint Industry Technical Committee to amend Order R111P, Leonetti Counties, New Mexico. And the purpose of the status here was to present what the parties had represented at the last meeting, were consensus edits to the commission's proposed order, which I did circulate Commissioner Bloom and Commissioner Poma this morning via email, which has the red lines. Mr. Felderwert, would you like to provide any comments on those red lines?
No, I appreciate the opportunity. I've looked at what the division had submitted, which are really amendments that appear to conform with the state archives and formatting. And I've looked at those and we have no objection to those red lines. And we had submitted some proposed red lines to the form of the order. As needed, I can discuss the reason for those, but I understand that council's reviewed them and they don't have a problem with them. So I leave it up to the chair.
Mr. Chair, members of the commission, I have reviewed the proposed order and it certainly meets with legal sufficiency.
And just for clarity, I had circulated 2 documents that were received by the commission clerk. Are they, Mr. Felderwert or counsel for the OCD, are those consolidated or are they separate, or is the proposal that the commission merge those the commission clerk and council need to merge those red lines?
Mr. Chair, this is Jesse Tremaine for the Oil Conservation Division. My understanding was that, well, I submitted through the clerk combined edits. So I took the JITC's proposed formatting edits and primarily recent ones focused on that finding section, and then added OCD's edits, a number of edits for clarity, just in terms of phrasing, some technical, minor technical edits, such as the designation indications of like feet and measurements, et cetera, those kind of edits, and a couple others. So those are combined in the latest document shared through Ms. Apodaca. And we do not oppose those edits proposed by Mr. Felderwert and the JITC. So this is intended as combined, but I wanted to leave them all as visible for the commission.
Thank you for that explanation, Mr. Tremaine. I'm sharing on the screen. I just want to make sure that commission is acting on the correct version. The document referred to as red lines, draft commission order, and they're 319-679-70.1 doc that has red lines to the header, order, edits to the finding, and then a handful of more targeted edits to the body of the document. Is that what the parties are proposing the commission adopt as the final order?
No, Mr. Chair, this is Jesse Tremaine again. The document, the latest version of the document is labeled as combined OCD JITC red lines to draft commission order with today's date.
I have that pulled up in front of me. I think we received it just a little bit ago.
Okay, let me just make sure.
8:02 a.m.
Yeah, okay. Okay, so this.
That's my bad.
All right, I see a separate. I'm just pulling it up on the screen. This is the file combined. OCD JITC red lines to draft commission order version it's not popping up because I minimized it, but this is the file you're referring to, Mr. Tremaine. V259-2024.
That is correct.
Okay. Yeah, I had, I think, all of them collectively open, so thank you for that clarification. I'm going to turn it over to my fellow commissioners to see if they have any comments, questions, or edits to those red lines.
Mr. Chair, I do not.
Mr. Chair, I
Commissioner
do
Palma?
not.
Can I get a motion to accept?
Mr. Chair, may I interrupt 1
Yeah.
minute? I apologize. I just noticed, and this is my fault. If you look at page 2, paragraph 6 and 7, they have a date of May 14th. The hearing was actually March 14th.
Okay, hold on. Let me just scroll down. Paragraph 6 and 7. So I'm sharing March 14th,
Yes, sir. I apologize for the error. That was mine.
right? And then that is
Yeah.
2. I'll just do a quick search. Yeah, okay. All right. With those 2 Scrivener's errors, which I will send to the commission clerk, can I get a motion to recommend commission approval of the combined party edits to the draft order in case number 23655?
I so move.
I second.
Roll call vote. Commissioner Bloom,
Approve.
Dr. Impoma.
Approved.
Let the record reflect the motion was approved unanimously, and Chair Fuge was voting remotely. Commissioners, we will get this cleaned up and likely circulate it to you for signature remotely. Although if we're able to get someone to do it while we're still here, we may get it. We may collect your signatures today, and I will sign it upon my return.
Very good. Thank you.
I believe that concludes case number 23655, and we will return to other items on the agenda. And the next case up is case number 23580. Are the parties ready to proceed?
Please have everyone in place, Mr. Chair.
All right. Again, coming over from the last one, I believe the commission's expectation was that we were going to have a joint scheduling, an updated scheduling order for this matter, which we had tentatively set for hearing which we had set for hearing at the April meeting of the Oil Conservation Commission. Is there an update from parties?
Mr. Chair, this is Jesse Tremaine for the Oil Conservation Division. I have circulated this morning an updated version with several proposed edits. Thank you to Mr. Davis for getting the first version of this rolling. As is the running theme, I noticed some edits due to some changes with the schedule and staffing and points of contact that needed to be made. So there was a revised version circulated to the commission about half an hour ago. And my understanding is that the that is in track changes. The parties are essentially in agreement generally to the changes. Pretty much everything is a modification to the previous order to update dates for the revised hearing schedule. However, we did propose a deadline for the parties currently entered in the case to propose any revisions. Based on the discussion of the parties, we do believe that there will be a revised petition that in certain aspects will look quite different than the petition currently before the commission. So we wanted to provide ample time for all notice and filing deadlines. And we're proposing a deadline at the end of the summer for the parties to submit any revised petitions. I threw out the September 6th date. I think the parties probably want to move that up to earlier in the summer due to some scheduling potential conflicts. And other than that, there were just minor updates and dates changed.
Mr. Tremaine, I don't have a copy of that in my email. I don't know if my fellow commissioners do.
We do not.
Can we ask the clerk to circulate that?
I don't have it either. If someone can send it to me, I'll be happy to circulate it.
In the dead air here, Mr. Chair, I am working on that right now.
Okay.
Mr. Chair, the previous email that I had sent, I just forwarded to Mr. Rubin, Ms. Apodaca, yourself, and Mr. Bloom. I don't believe I have Commissioner Mpoma's email.
I just forwarded it along. Okay, so Mr. Tremaine, just waiting. Can I confirm my fellow commissioners have that document?
Yes,
Mr.
sir.
Chair,
Thank you.
Mr. Chair, Mr. Tremaine, I haven't received it yet on my screen. Perhaps someone can resend it to me.
Because it went to a state personnel office address. Here you go, Council Rubin. Just send it to you.
I know our email changed from NMAG to NMDOJ at some point. That might have been the issue. I guess this passes for suspense. I'm still waiting to get it. Okay, I just lost the internet. That was why. Dr. O'Connor, can I just take a look at yours? Taking a while.
Do you get it, Mr. Rubin?
I am reviewing Dr. Mpoma's laptop right now. Just take a few
got it.
moments. Mr. Chair, members of the commission, yes, I've reviewed it, and it certainly meets with legal compliance.
Thank you, Mr. Rubin. So Mr. Tremaine, now that we have the order up, and I will just go ahead and share for clarity. Walking through the edits that you explained, Mr. Tremaine, obviously, commission clerks will provide WebEx information for those dates. And Mr. Tremaine, is it paragraph 1 that you were explaining before we got it, which was the revised petition, and the parties' proposals that there may be a revised petition coming, and that it would be submitted no later than September 6th?
That is correct, Mr. Chair. It's the division's position that due to expected changes in the current petition, that we do need to set a date certain for at least any core revised petitions. Certainly, the commission could consider any amendments or parties not currently entered in appearance, any proposals they would make at a later date. But to make sure that we have complied with all notice requirements, we're proposing at the latest that September 6th deadline for these parties.
Okay. And then otherwise, Mr. Tremaine, as I'm looking through this, aside from changing personnel that have shifted over and other similar edits, that this appears identical to the prior scheduling order in this case, except for the revised petition provision in paragraph 1.
That is correct.
Do my fellow commissioners have any questions?
No, Mr. Chair.
No, Mr. Chair.
And I'm going to ask Council Rubin, because I've got a question. I think we had discussed assigning a hearing examiner in this case, and the other ones. The other matter we're discussing, Mr. Rubin, do you believe that needs to be listed in the procedural order, or can we do that separately?
Mr. Chair, members of the commission, we could, it's really at the pleasure of the commission. I think best practice would have the hearing officer referenced in the procedural order, though.
Okay. I'm going to float a potential motion for consideration or float a potential concept for consideration by my fellow commissioners. The New Mexico Energy, Minerals, and Natural Resources has 2 hearing officers under, sort of longer term contract. Miss Felicia Orth and Mr. Rip Harwood. They're already under contract both in this fiscal year and next because it's a multi-year contract. Would the commission be comfortable moving to authorize me as the chair to finalize the procedural order with the hearing clerk to fill in the missing information, and then designate a hearing officer in the final order by selecting from either Mr. Orth or Mr. Harwood based on their availability to support this hearing date?
Yes, Mr. Chair, I would so move.
Mr. Chair, I second.
Roll call vote, Commissioner Bloom,
Approve.
Dr. Impoma.
Approved.
Let the record reflect, the motion was approved unanimously with Chair Fuge voting remotely. Parties, we will get this cleaned up and issued shortly.
Mr. Chair, if I may,
Yes.
just a few quick issues. I'm actually looking at this draft on my phone, but I noticed in the first paragraph, I believe the original February hearing dates are still in that opening paragraph.
Yeah, I will highlight that as an update,
And
the
then
appropriate hearing date.
the deadline for technical testimony in this draft is October 21st. In the original order that the commission entered for the February hearing dates, there was actually a 4-week time period between the start of the hearing and the deadline for technical testimony. That's been moved to 3. Guardians would prefer 4 just to give us a little extra time. But I don't know what the position of the other parties is on that, but the original deadline that I circulated was actually based on the order that the commission entered for the February hearing dates, which was a 4-week lead-in time. I have no other issues with any of the other dates. The only other issue I'd like to raise is the deadline for the revised petition. We agree that that's needed. The scheduling conflict in early September, that is my scheduling conflict. And I would just ask that deadline be entered no later than the week of August 19th through 23rd to avoid any conflict in my schedule. And that's all I have. Thank you, Mr. Chair.
Any of the other parties have comments on those?
Mr. Chair, this is Jesse Train. The apologies, Mr. Davis, that is correct. I did leave that edit in from the proposed 14th to the 21st. OCD does not oppose either 3 or 4 weeks on that at the commission's preference and discretion. So the 14th or the 21st for that technical testimony is fine. And the August dates for the revised petition deadline are also acceptable to the division.
Mr. Feldort?
I'm actually the one that proposed the October 21st only because it seemed to me, I couldn't understand why we needed over a month before the hearing to file the exhibits and the witness statements, which is a substantial undertaking. So that's our preference would be the 21st, recognizing that normally, if you look at the commission's rules, you don't file your exhibits and witness pre-hearing statements sooner than 10 days before the hearing. I understand wanting to have a little more time, but it seems to me like a month before the hearing is an unusually long period of time.
Looking at my fellow commissioners to see if they have comments.
No, Mr. Chair.
Dr. Impoma?
No, Mr. Chair.
I would propose hearing it, entertain a motion on the first revised petition date to adjust that back to Friday, August 23rd. And I'm inclined to leave the technical testimony date as currently proposed for October 21st.
That would work. Mr. Chair, are you looking for a motion?
Yes,
Then I would so move.
I second.
roll call vote, Commissioner Bloom,
Approve.
Dr. Impalma.
Approved.
Let the record reflect the motion was approved unanimously with Chair Fuge voting remotely. Parties, we will go ahead and get, let me just make that, since I have it opened. It's 23rd. We will get the order cleaned up and issued shortly. Thank you.
Thank you.
Thank you, Mr. Chair, Commissioners.
All right. We will go to the last case, but series of cases. Case number 24277, 24278, 2413, and the associated division cases that were before us. And again, this is a status conference to discuss a scheduling order in these matters, which we set for hearing at the last meeting of the Oil Conservation Commission. And there were also subpoenas and motions filed in advance of this hearing. And absent feedback from contrary feedback from the parties, the chair's inclined to start with the scheduling order and then move into a discussion of the subpoenas.
Good morning, Mr. Chair. Good morning, Commissioners. This is Adam Rankin, appearing on behalf of Goodnight Midstream, Permian LLC, Santa Fe Office of Holland and Hart. I have no objection to proceeding with items that we agree on in the initial case.
Sounds good. Okay. I believe we got a scheduling, well, the commissioners received a scheduling order prior to, as part of our packets. Is that a consensus scheduling order? Or is there discussion needed? Can the parties please provide some feedback on that order that was included with our materials?
Good morning, everyone. Sharon Shaheen, Empire Petroleum. We did circulate an agreed scheduling order. I believe, Mr. Rankin, it was Monday evening. Is that right?
That's probably about right when it was effectively circulated, because I circulated the wrong link. But yes, I think it was Monday evening when we circulated it.
And we're happy to discuss the provisions of the scheduling order if you like, but as Mr. Rankin has emphasized, we did agree on the dates that are in here. I would note that with respect to paragraph 2, those dates regarding the motion on the scope of the hearing, those dates correspond with the commission's previous indication that it would hear that motion on at the June 20th scheduled hearing.
Okay. I'm just opening it up.
Mr. Chair and Commissioners, Chris Moander on behalf of OCD. Just by way of a bit of background, this was generated out of multiple meetings between council. So there was real substantive work done behind this. And I do believe, for Ms. Shaheen, that it's probably the only thing that I would bring the commission's attention to is that paragraph 2, which I do believe is consistent after having looked at the record.
If it's helpful, Chair Fuge, we can kind of just briefly summarize the elements and the thinking behind it. It would be helpful as you peruse it. But essentially, we've agreed on the dates previously for the hearing, which is September 23rd to the 27th, which we've indicated. As Ms. Sheen noted, we've agreed pursuant to the commission's request for a briefing schedule to address the scope of the hearings. We've also agreed to disclose each of the parties' witnesses, their area of expertise, and the subject matter in which they will be testifying by a date in advance of the technical testimony. In addition, we've identified the last day for discovery, essentially last day for issuance of subpoenas, including subpoenas for witness depositions, which will be towards the end of July. We've also agreed on a deadline for discovery, rather a deadline for motions to compel in advance of the deadline for discovery in August, and briefing on those any disputes that may arise. Also, you'll see that we've agreed to submit written technical testimony, as we discussed previously, 4 weeks in advance of the hearing date. In addition, in order to help streamline discovery and disputes over information that's being relied upon, we've, and this was to Empire's credit, they provided provisions that would require the parties to provide information that they rely on or referenced in their testimony, both in the direct testimony and the rebuttal testimony, within a week upon request without issuance of a subpoena. And then also deadlines for dispositive motions will be towards the end of August in advance. I think that's the same date that testimony is due, initial direct testimony is due. And then provide at the commission's discretion that arguments on those dispositive motions would be heard at its regularly scheduled September 19th hearing date.
Okay.
We've also provided that at the time pre-hearing statements are filed, that the parties would provide their list of issues they believe are common to all the applications or cases, and then issues that are unique to any specific application to help sort through issues that may be contested. Trying to think that those are sort of the highlights. Anything to add, Dana or Ernie or Chris or Sharon?
Mr. Chair and Commissioners, I think that, not to put too fine a point on it, but there's been discussion about the concerns about discovery, and I use the discovery in an administrative case, and this is the party's best efforts to streamline that, remove obstacles that might delay the hearing. Parties are eager to get this hearing moving forward. So there was some creativity in this, but I do think it meets the needs of each party, having discussed and the anticipated needs pretty thoroughly in prior meetings.
I would just add to Mr. Rankin's description of the provisions that the last couple of provisions relate to rebuttal testimony and exhibits, and those will be filed in advance of the hearing as well. And objections will be filed no later than Monday, September 16th. So we should be able to settle any issues prior to the beginning of the commission hearing that last week in September.
Thank you. I don't have any substantive questions on the procedural order. I appreciate the comprehensive thought that went into this. In looking at it, I think the only amendments that we would make are administrative in nature. You know, as the parties know, or at least that I would propose, the commission hosts its meetings with a virtual format. So we would add those, at least for those dates that weren't already normal commission meetings. For the special hearing, we would add those dates for the procedural items to the agenda. And I believe too that the commission should designate a hearing examiner, and as in the prior matter, we would look at selecting from one of the two that are already under contract with the Energy, Minerals, and Natural Resources Department. But I wanted to see if my fellow commissioners had any comments or questions on the scheduling order.
No, Mr. Chair.
No, Mr. Chair.
I then would seek a similar motion as I did in the prior case with respect to the scheduling order, approval from the commission to issue a scheduling order under my signature as chair, with the only edits from what's presented by the party are information necessary to facilitate remote participation in those hearings, and designation of a hearing examiner selected from either Mr. Rip Harwood or Miss Felicia Orth, based on their availability.
Mr. Chair, I would so move.
Mr. Chair, second.
Roll call vote. Commissioner Bloom,
Approve.
Dr. Mpoma.
Approved.
Let the record reflect the motion was approved unanimously, and Chair Fuge was voting remotely. Thank you, everyone, for coming in with a detailed scheduling order here. I think the next item, and we alluded, some of the parties in their comments alluded to this, are a couple of our discovery related. And the first, well,
Mr. Chair, I'm sorry to interrupt, but I'm wondering, I just wanted to bring up one other housekeeping matter to address. That's sort of in the procedural nature before we get into the substance of discovery disputes. The division may or may not be, or the commission and the chair may or may not be aware yet, but Empire has filed 8 additional applications to revoke the injection authority for other operators in the unit and outside the unit boundaries with the division. So I just wanted to bring that to your attention. As you are well aware, and Empire is well aware, it's been our position that all the injection operations within the unit ought to be heard together. So in terms of procedural issues, I just wanted to make sure the commission and the chair were apprised of that fact. Since our last status conference, those cases have been filed and are pending before the division. Each of them, I believe at this point, have been objected to proceeding by affidavit before the division. I believe counsel has been retained for each of those operators, but I think they're still sorting out the facts and how they want to respond or handle those applications. But I did just at least want to apprise the commission to that fact.
Mr. Rankin, just to make sure I'm following, these are objections filed by Empire against other SWD operators in the same unit that is at issue here?
Mr. Chair, yes, there are actually 2 units now at issue. One is the Eunice Monument South unit, which is the one at issue with Goodnight Midstream. And there are additional disposal wells in the Arrowhead Grayburg unit, which is also operated by Empire to the southeast. In addition, there are wells in between the two that Empire is seeking to revoke authority for that are not Goodnight's. So it's helpful to look on a map perhaps. I haven't mapped out exactly which ones they're seeking to revoke, but I do have a map that shows them all. There are some in between that aren't yet subject to applications to revoke, but nevertheless, that's the status. There are 2 units now at issue, the Arrowhead Grayburg and the MSU, which is the one at issue with Goodnight's cases, and then some SWDs in between.
Mr. Rankin, is your suggestion that either the division or Empire may send those filed cases up to the commission? And I would like to hear from Ms. Shaheen to get Empire's perspective on that question after you respond, Mr. Rankin.
Mr. Chair, as you may well expect, I think when we prepare and submit our motion to address the scope of the hearing, we'll be making the argument that wells that Empire is seeking to revoke within the Eunice Monument South unit, the MSU unit, ought to be heard together. And our view is that those wells and cases should be heard separately in the initial instance, because those are most directly at issue with the unitized interval. As you look at the scope of these cases and the distance, I think you'll quickly understand that these are maybe becoming unwieldy, and we ought to focus initially on the unit itself, the EMSU.
Ms. Shaheen?
Thank you, Mr. Chair. I believe our position at this time is that those cases should be stayed in the division pending conclusion of the hearing on the Goodnight related applications. However, I'll note that I have not yet had the opportunity to confer with other counsel. I'm actually not aware of counsel for OWL yet, but I was planning to speak with counsel for Rice in that regard. So I think any decision about what should happen with those cases should await the status conferences that we anticipate in the division a week from today.
Okay.
Mr. Chair?
Council Rubin?
If I could ask the parties just for my own edification, these additional objections, Mr. Rankin, would they involve additional parties to those that are presently before us?
Councilor Rubin, yes, there are 3 different operators at issue in those 8 other cases before the division. 6 of the cases involve Rice operating. 1 involves OWL or Pilot. Another case involves Permian Line Service, which I believe is a related entity to Rice operating. So there will be additional parties with those additional cases. I don't disagree with Ms. Shaheen. I have been in contact with counsel for these other parties, but they don't yet have a position on how they want to handle those cases. So I don't want to represent where they stand at this point. I bring it to your attention because, Mr. Commissioner, I don't want there to be a delay, if at all possible, or for us to be accused of causing a delay, where our position has been clear from the beginning that these cases and these disposal wells should be heard together.
And this is potentially a question in part for Council Rubin, but it sounds to me like we don't have all the parties in those cases, so there's really nothing dispositive for us to do there. Appreciate the note for the record that there may be related interests that the commission needs to consider, but it sounds like there are additional near-term proceedings before the division that may resolve some of those questions. And I'm not sure the commission's in a position to do anything beyond noting there may be potentially related cases pending before the division, but that are not currently before the commission.
And Mr. Chairman, members of the commission, the reason I asked the question, I was just thinking in terms of administrative efficiency, that if we had all the parties here, the fact that other cases were not joined, but they involved the same parties, there's a good argument as to estoppel. But if there's additional parties, what I think the commission has to balance is hearing the same technical testimony, deciding the same substantive issues in 2 separate cases versus consolidation. And of course, being mindful of the delays in the current cases. I think that's what the commission has to consider. Thank you.
Would the suggestion then be Council Rubin, that we direct those parties to appear at the next hearing and provide us with their perspective on these matters?
Mr. Chair, I think that would be advisable. Can't force anyone to show up, of course, but I think it would behoove them to do so, so that the commission could make and also we could see what the parties can consent to with respect to consolidation and how the parties would balance the delays. We probably want to know that before our next meeting.
Mr. Chair
Ms. Shaheen?
and Commissioners, I would offer that Mr. Rankin and the rest of us could confer after the status conference next week and perhaps provide you with a status update on those cases.
I would be amenable to that.
I think that's fair. I think my concern is well stated by Mr. Rubin that there's concerns about estoppel or preclusion if parties don't have an opportunity to state their case in matters that directly implicate their operations. I think it's important to have everybody at the table. So that's my view.
And Mr. Chair and Commissioners, OCD would agree with that. If there's the potential to bring in other parties, due process, estoppel, as Mr. Rankin said, doing that should protect everybody's rights and make sure we get the cases tuned up for hearing.
Council Rubin, do you think we need a motion here or just a direction to the parties that they should provide us with an update no later than May 17th, which should follow the status conference in the next scheduled division hearing?
Mr. Chair, members of the commission, what's before the commission today is approval of the scheduling order in the current case. I don't have a full grasp as to whether this scheduling order should be approved and we continue along this track for now, or if we should just hold that approval of the current scheduling order in abeyance in light of the new developments. Do the parties, as it was submitted by the parties, do they have a preference as to whether we continue with at least considering perhaps approving what's before us today?
Council Rubin and commission members and Chair Fuge, I'm okay with approving where we are today. I do not want to be seen as delaying any of these proceedings. I do have grave concerns about doing so where we know that there are other parties similarly situated who have the same claims and defenses not being part of the matter. So I think it's important to, I think at the earliest opportunity, bring those parties in. The commission director has previously directed matters to be presented before the commission when they implicate substantive policy matters or important matters that should be heard by the commission in the first instance. We already have made that decision with respect to disposal in the unit and around the unit with respect to these cases. And so I don't see any reason why these cases before the division shouldn't be directed to the commission and referred to the commission to be heard with these goodnight matters. So I think, obviously I haven't filed a motion to do so. I was deferring to the ability to communicate with counsel and other parties. But that said, I do have concerns about the current posture of these cases procedurally. And I just want to make that known.
Council Rubin, Commissioners, Mr. Chair, I think that the scheduling order before the commission, at this stage only concerns cases that involve, at this point, Goodnight Empire and the division. I do think it'd be appropriate to get that entered so we have some structure and we can get moving. This commission has an abundance of flexibility within its jurisdiction and authority. And if there become issues down the road, then I would anticipate discussions about revising the scheduling order may well be had. But this order in and of itself would not necessarily at this stage impact these other parties. And OCD would like to see some guardrails put on the cases so we can get things moving on at least these. And if other parties come in, they're not likely involved in some of the subject or the specifics of these cases. So OCD would prefer to get an order entered now, and we can easily revisit as needed down the road, depending on what happens with the lingering cases Mr. Rankin referenced.
And just so as I'm following the proposed scheduling order that we did move to authorize adoption of with the noted amendments. If other parties have interest, but as I'm reading through it, and I just want the parties to confirm this, under paragraph 2, there'll be motions filed regarding the scope of the hearing no later than the end of this month. Sort of with conclusion of briefing by June 13th. But that motion actually wouldn't be decided until later, until September 19th. Is that the proposal? And what I'm getting at is just how it would impact parties who might come in and might want to adjust it. Obviously, we can put a scheduling order in place for the cases before us, and we have had additional ones. We can change our scheduling orders, but I wanted to get a little perspective, and I'm just thinking to prejudice and administrative efficiencies of other parties who might or might not appear before us.
Mr. Chair, Commissioners, Councilor Rubin, with respect to paragraph 2, those dates were set so that the motion could be heard on the June 20th regularly scheduled hearing date. And what I would suggest is that those motions address these additional applications, and those parties could appear at the June 20th hearing, and the commission could consider the scope of the hearing, including whether the Rice applications and the OWL application should be heard as well in the same proceeding.
Got it. And Ms. Shaheen, Mr. Rankin, it is your representation that there will be a status conference in those division cases next week.
That is correct. I believe the Rice attorneys have already requested a status conference. I anticipate that Rice attorneys will enter an appearance and do the same, and if not, we'll be requesting a status conference on that.
Okay.
Mr. Chair, if I could, I just want to be clear with Mr. Rankin that there is consensus before the commission today on this order. With your caveats, I don't think that rose to level of withdrawing consent, correct?
Mr. Rubin, I'm not withdrawing consent.
Okay.
I do, however, strongly believe that it's within the power of the commission to refer those cases to the commission directly. And I think it's appropriate to do so. And I don't want to delay that. And I may, do something, if the commission won't decide it's on its own, I may, take action to file a motion sooner than later. I don't want to do so at the opposition of those parties necessarily, but I do think it's important for them all to be at the table. So no, I'm not withdrawing consent on the order, but I think I have done so, expressed my view on the importance of having them all together. Empire Council has made the argument repeatedly that all the Goodnight cases should be heard together. Because they're all similarly situated, similar issues, similar technical issues. Their experts will address the same issues with respect to all of our cases, no matter whether they're in the unit or outside the unit. I don't see why, on that basis, these cases should be stayed at the division level. They made the very clear case that when I moved to stay cases outside of the unit boundary at the division so we could focus on the unit, that they took the position that all the cases must be heard together and must be heard rapidly to avoid impact to Empire's operations. So on that basis, I don't see why there's a distinction here with these other cases. So I've had my say. And I believe after conferring with other counsel and with Empire Council, we can hopefully provide you a report after the status conference at the division, and then we'll go from there.
Okay. Again, I continue to be of the view those parties are not before us at the moment, but duly noted. And we will wait, the commission will wait for the update following the conclusion of that status conference. And otherwise, we'll proceed to finalize the scheduling order as proposed by the parties with the additional information noted in the approved motion. Moving on to the other items in this matter that were included in the agenda for potential action by the commission. There was a proposed subpoena filed by Empire Mexico LLC through its attorneys for issuance by the commission. And then there was a motion to quash a Goodnight Midstream subpoena that was issued by the division, filed by Empire, and a response was there. Appreciate that these are two separate filings and two separate matters. Have a general question. Obviously, this relates to discovery questions that are part of the proposed scheduling order that we will be finalizing and issuing. Is there a reason these should still be heard today and not just follow the procedures under that order?
Mr. Chair, Commissioners, Dana Hardy with Hinkle Shaner on behalf of Empire, New Mexico. I think it would be appropriate for the commission to address these matters today or soon thereafter to allow the parties to continue preparing for the hearing. I think the procedural order sets out deadlines in the expectation that we are able to resolve issues by certain dates in time for the hearing, but I think if we can resolve them earlier, that would be preferable. And I think these matters, at least the motion to quash, has been fully briefed. We did submit a reply late yesterday for the commission's consideration that summarizes the issues and also addresses the documents that have already been produced. So I think that's important for the commission to consider, but I do think it's appropriate for these issues to be addressed expeditiously.
Mr. Chair, members of the commission, I have not had a chance to review the reply filed by Ms. Harvey for today. So if in the interest of having advising the commission properly, I would like the time to review the reply and not rule on the motion today. Okay.
Duly noted, Council Rubin. I think now that we have a scheduling order in place, and I think we'll be having a substantive hearing in June on motions under the scheduling order that was just put in place. My proposal would be that would be an appropriate time to make a decision on the subpoenas and the motions. Mr. Rankin.
Thank you, Chair, Fuchs, Commissioners, Mr. Rubin. I don't disagree with Ms. Hardy that these matters should be heard and resolved expeditiously. Part of the reason is that the discovery that Goodnight is seeking in this subpoena that's currently being disputed has been pending now for some time, in part because the subpoena was submitted to the commission or the division director for a period of time, and we were waiting for it to be returned so we could issue it. And then we've waited a month for Empire to respond And instead of responding, they filed a motion to quash and respond at the same time to some of the requests. The request that the information that we're seeking in this subpoena is critical to our ability to prepare for the hearing and for our experts and our witnesses to review information that may be contradictory to Empire's positions and testimony that they've already submitted. So the sooner we have access to that information, the more expeditiously we can prepare for hearing. Now, I've in discussions with Ms. Hardy and Counsel for Empire, I have noted, and as well in the scheduling order, it's noted that the division director serving as chair of the commission is authorized by rule to make decisions on non-dispositive motions that are before the commission. I do think it would be beneficial, however, for the full commission to hear the substance of the disputes over the factual issues, because I think it would help the commission, it would inform the commission on the nature of the arguments, the technical issues that they will be hearing in September. So while I think it's important, I guess what I'm trying to say is I think it's there's an opportunity for an expeditious review and decision by the commission director, and we can potentially have a separate pre-hearing conference to address arguments on the motion. But I also believe it's important for the full commission to hear and understand the nature of the factual disputes, because I think it will help them understand the nature of the case that they're going to be hearing in September. So with that, I just wanted to kind of suggest that maybe there's a way we could have a special hearing in advance of the June regularly scheduled hearing to address this discovery issue.
And Mr. Chair, Commissioners, and Council Rubin, I owe an apology here because I have had about a month to go through all these cases and I didn't get a response in on this, but I did want to make a few points on the record. Number one, I do agree with Mr. Rankin's view on this, that I think that the commission, this is a unique case where the commission would benefit a great deal from hearing about each of the operators' cases. But I think more importantly, this is an attempt from both sides, I think, to try to get a bit ahead on discovery such that we can get this information out sooner rather than later. I'll represent that OCD is interested in seeing what would be generated in response to all the subpoenas, because we don't have access to some of the particular information and data that's at issue there and would be relevant to OCD's case. And so it is a unique situation. It is slightly abnormal based on what the rules would allow. It doesn't require that the chair sign. So OCD would like to have these heard as well and would support that the subpoenas be issued.
Mr. Chair, may I?
Yes.
I think that the briefing fully addresses the issues that have been raised by the subpoena issued by Goodnight and Empire's response. I think it might be helpful for us to have argument on the issue, but I also think it would be acceptable for Mr. Chair, for you to rule on the motion to quash based on the briefs. I think the briefs are thorough and address these issues. With respect to Empire's request for a subpoena, no motion has been filed on that. We're just waiting for the subpoena to be issued. So on that one, I think it would benefit everyone to have it approved and issued so that motions can be filed if necessary.
And my question though, maybe I'll restate it, is the first set of motions under paragraph 2 and 3 of the pending scheduling order is to talk about the scope of the hearing. And as I reviewed, well, on the subpoena that's subject to motion, one of the issues are relevance and scope of the discovery requests sought. And so it seems tricky to resolve that if the commission is going to narrow the scope of the issues to be heard or potentially expand, either way, but to make a decision based on filings from the parties. It seems a little hard to get at one of the core questions, at least that jumped out to me in the motion practice on the subpoena and motion to quash. There was some questions about scope and sort of relevance to the hearing. And it seems to me like if the commission's going to make a decision on that based on briefing filed by the parties, that we need to do that first before potentially resolving discovery disputes that at their core do raise questions of relevance.
Mr. Chair, I guess I would respond by saying that at this point, Empire's position is that all the cases should be heard together at once, and that there should be no bifurcation or limitation on the scope of the hearing currently before the commission. And so that on that basis, I don't see necessarily a reason to limit the assessment of the objections because there's as Empire's position is that everything should be heard at once. So that's one response. I do appreciate, however, the concern about scope and relevance. And it's a fair point. And I don't think in my preparation for today that I duly considered the nature of their objections vis-a-vis considerations about scope of the hearing as between matters in the unit boundary and outside the unit boundary. I do believe, however, in my view, and the reason I didn't give that consideration was because I believe that there are arguments about relevance and scope are not germane to that issue. There are arguments about relevance and scope are more about the nature of the documents and information sought being outside the nature of the cases as opposed to whether they relate to discovery matters outside the unit boundaries or the scope of the proper scope of the hearing. And Empire can certainly, Council for Empire can certainly address that. But my impression of their arguments around scope and relevance, or rather relevance and burden, do not relate to whether the hearing includes wells inside the unit or outside.
Mr. Chair.
Yes, Ms. Hardy.
That's correct. Our objections are based on our concerns generally regarding the overbreadth and unduly burdensome nature of the request. I don't think that they are dependent on a final determination on scope. I think generally we've raised the issues that of relevance such as matters regarding, surface agreements with a landowner that has filed litigation against Goodnight. I mean, they've asked us to produce communications with that surface owner. And we've told them in another case that we don't have any, and they have that information. It's attached to our reply. So those are the types of things that are addressed in our objections. It's our position that their requests go way beyond the scope of permissible discovery in a commission proceeding and largely even in a district court proceeding. So I don't think that evaluating those objections is contingent on a final determination regarding the scope of this hearing.
I'm going to look to Council Rubin for maybe some guidance here. In light of the Oil Conservation Commission rules that allow the chair to rule on non-dispositive motions, Mr. Rubin, should we just take this under advisement and confer on these filings? I have reviewed in advance the motion surrounding Goodnight subpoenas, except for Ms. Hardy's reply. Given its return, I was not able to review that in advance. Should we just confer separately on those procedural matters, given the commission's rules?
Mr. Chair, members of the commission, yes, you are correct that it's certainly a non-dispositive motion. I had presumed, in fact, perhaps, without making that presumption clear, that the whole commission wanted to consider this. But I think that is it certainly would be within it would leave both options open, Mr. Chair, if we tabled this matter for today. And you could either rule upon it pursuant to the rule, or we could, after you and I confer, and I have then had a chance to review the reply, it still leaves the option for us setting a special meeting just for the sole purposes of deliberation and perhaps oral argument. So in light of that, I think tabling would be appropriate at this time.
I'm going to look at my fellow commissioners if they have any concerns or questions with that. I worked with the commission clerk to include this so the whole commission could hear about some of these discovery questions, but I do want to assess if my fellow commissioners are comfortable with me and Mr. Rubin conferring on this under the OCC rules and making an assessment of what to do with these subpoenas, which may include a special meeting if we determine it's necessary or appropriate.
Mr. Chair, Mr. Rubin, I would be comfortable with that. And at some point I may call Mr. Rubin and ask for a little guidance here. Just might have a couple questions for him once I dig into this. Thank you.
Mr. Chair, Commissioner Bloom, we do have to be mindful of the Open Meetings Act. And if I confer with you and then I confer with the chair and that somehow affects the decision, it would be improper unless it was at an open meeting. So it's sort of, you need to decide if you're okay with the chair and myself doing it, or if you'd want to have it heard at a special meeting. Or at least letting us decide that.
So, Mr. Rubin, you would be uncomfortable with just questions of a general nature about the potential path for these?
Oh, no, I mean, I would certainly always listen to any question you have, Commissioner Bloom. Just
yeah, I think we have to be cognizant of a rolling forum, of course. But
yeah,
I don't
that's
think
all.
we'd be touching on that.
Okay, thank you.
Mr. Chair, if I may just interject one last thought here. I do think that expedition and is a key. I do think, however, as I stated, that one option may be, Mr. Chair, if in review of the reply brief and the briefing, if there are specific questions or concerns, I do think it would be helpful to have some argument from counsel. I don't think it necessarily needs to be extensive, but I do believe that there are some matters that can be more particularly articulated now that the briefing is complete, and it may help the commission understand the nature of the issues at dispute. So I would just offer that, before making a summary determination, I would be willing to set aside any other matters to have an argument or a short conversation with Empire Council and yourself or the full commission to address any questions that you all may have.
Thank you, Mr. Rankin. I think as Council Rubin articulated, one of the things that he and I will discuss as we're reviewing things under those rules is that question whether the matters would benefit from argument or can be decided, can and should be resolved on the papers. So again, we'll table both of these items and we'll be in touch with the parties.
Mr. Chair, one more housekeeping matter, if I may.
Yes.
There is a pending motion to dismiss in two of the cases. I believe they're case numbers 24277 and 24278. And I believe that motion has been fully briefed. It is, relates to the scope of the hearing, so I would suggest, if council agrees, that that motion to dismiss also be heard on the June 20th hearing, if not sooner.
Mr. Chair, I would encourage the commission to hear those dispositive motions on the June 20th docket. I believe there will be another set of motions similarly dispositive. I think will help also inform the commission again more fully around the issues that are at stake here. So I agree with Ms. Shaheen. I think June 20th is an appropriate date for consideration of those motions.
And Mr. Chair, if I could have just one moment, I need to check on something because I do have some thoughts on that. And I apologize. I did. OCD got served a little late on this motion. They will be filing something on it as well, but I think the 620 would be good to have that addressed as well, because I think that, if I'm not mistaken, that would be every motion that's outstanding thus far would be at that point determined, or at least be set to be heard, which would clarify a lot of the muddy waters currently.
Mr. Moander, my view of paragraph 2 is that what we are teeing up, yes, pending motions that go to the scope of the hearing would be teed up for the June 20th hearing, in my view, under the scheduling order, and they were not noticed or set for hearing today because we needed a scheduling order in place so we could decide how to orderly proceed with this matter. Anything further from council in any of these matters?
Mr. Chairman, Ernest Padilla, asking about the status of our pending subpoena. As I understand it, you're going to table that for now.
Mr. Padilla, yes, both subpoenas will be tabled, and I'm the chair is going to confer with Council Rubin and make an evaluation and decision how to proceed.
Okay.
Anything further?
Thank you for your time and consideration.
Yes, thank you. Nothing further from Empire.
Nothing further from OCD.
Excuse me, Mr. Fuge. I've been handed the final order on case number 23655, accepting all of the tracked changes, and it's ready for signature if you want me to present it to the commissioners.
Yes, if you could please present it to the commissioners, Sheila, that would be great.
Okay.
Walking through the last item in the agenda, pending litigation, we didn't list it, but Mr. Rubin, we've had the Atencio case on a number of the agendas, and I know there was argument in substantive motions there. Have we received a ruling from the court?
Mr. Chair, members of the commission, no, there was extensive oral argument several weeks ago, and we are awaiting a decision from Judge Matthew Wilson, and I will circulate that upon receiving it.
Perfect. Thank you. Any other business? Hearing none. Our next meeting is June 20th, 2024, and the meeting of the May 9th meeting of the New Mexico Oil Conservation Commission is otherwise adjourned.
Thank you, Mr. Chair.
Thank you. Everyone has a good day and a good weekend. Commissioner Bloom and Commissioner Poma, OCC clerk will give you that order to sign, and I will finalize it and distribute it upon my return tomorrow. Thank you.
Thank you.